Texas Trucking, cause number GN23-004646. Counsel, go ahead with your appearances.
Yes, Al Silverio on behalf of the plaintiff, Roberto Fuentes.
Chuck Shiver for the defendant, Texas Trucking.
All right, and the movement may proceed then, Mr. Silverio?
Silverio.
Silverio. Okay, go ahead.
Good morning, Judge. This is a motion to compel. We're also asking for sanctions as well due to some just conduct that we'll discuss here in a bit. But just to give you a little bit of background about the case, this arises out of a construction injury that took place at a Jimmy Evans work site down in Buda. Basically, the defendant, Mr. Ulloa Sanchez, was driving an 18-wheeler for his employer, and he's essentially dumping material from his trailer onto that Jimmy Evans job site. He finishes doing that, and somebody there at the job site, we're not sure who yet, we're still in the process of discovery, but that individual lets Mr. Ulloa Sanchez know that, hey, there's still material in the back of your trailer. So Mr. Sanchez goes on to continue dumping. He's now moved to a different location and begins dumping the remainder of his materials. Problem is, he does that on an uneven surface, so the entire trailer and its contents tip over onto our client's the hood and cab of our client's 18-wheeler. So we filed suit on this case against the driver of the 18-wheeler, Mr. Sanchez, filed against Jimmy Evans, who's the owner of the job site. And we also filed against defendant Texas Trucking, who's here today, as they are the dispatcher, and it's our understanding that they were kind of overseeing and running the job site. That's a little bit of background about the case itself. Now, what we're asking for, Judge, in our motion to compel, we issued pretty standard discovery requests. We asked for things like incident reports, disciplinary measures taken as a result of this incident. We asked for any excess insurance policies, among a number of things. I'm happy to go down them one by one if you'd like to do that, Judge. But basically what we've kind of faced on this case, dealing with counsel thus far, is even us getting the insurance policy that's required by the initial disclosures, that was an uphill battle. Counsel for weeks refused to produce that to us, even though there's no objection to be made there. And finally, they did produce it. But now, we reviewed defendant's discovery responses. Essentially, nothing was produced. There's just boilerplate objections and assertions of work product and attorney-client privilege that are improper under the rules. We attempted to discuss our issues with the discovery deficiencies with counsel, and the response that we were met with was, we're standing on our objections, go ahead, set it for hearing. I hear the court setting hearings in February. So I hate having these hearings. I don't think that they're productive, and in fact, I was able to hammer out these issues with the other three defendants in this case. But we haven't been able to do that here today. So we're here asking for you to rule on these objections and assertions of work product and attorney-client privilege.
Mr. Shiver?
Thank you, Your Honor. A couple of facts that are important you need to know about. He has described the accident, how this happened. One truck rolling over, some sand poured through the window on the plaintiff's truck, and this is an extremely minimal damage case with basically some sand spilled on this individual. He pointed out there that we all know who the driver of the other truck was. We know who their employer was. We know who the owner of the equipment was. We know who the premises owner was, and we are none of those. We're a non-involved party in this case. And plaintiff should note that his own pleadings have pled only that we dispatched the truck. That's false, number one. And number two, it's also irrelevant. And as you see, as we get into a lot of these requests here, why we've taken the position, and frankly, I object to the other side claiming the position that if we follow the rules of civil procedure, that that's somehow obstructionist. We have a motion for summary judgment that's pending, and right after that, a frivolous groundless pleading sanction motion is going to be pursued. We have a case here that's been on file for a year and 4 months. He hasn't taken a single deposition. He's done nothing to be diligent about moving the case forward, but he has time to come after a non-involved party for this kind of nonsense. I have multiple serious fatality cases where plaintiff's attorneys don't go after the claim file and reservation of rights letters, but that's what we have here. Now, in this case, 5 of these requests today that are disputed relate to privilege. And the plaintiff's attorney seems to have a complete fundamental misunderstanding of privilege. He's asserted that it only applies once defense counsel is hired. That is incorrect. He seems to believe it only applies to communications between the defense counsel and the defendant, and that is also not correct. He has here asked on 5 of these disputes for incident reports. And of course, we have lots of objections about what that means in the first place. But if we come down just to the core of privilege, we've provided the affidavit of the adjuster, Todd Hasty, that's an exhibit here uploaded to Box, and also provided to the court counsel or the court personnel ahead of the court today, who's noted when and how the case was first revealed to the company, that the anticipation of litigation was on March the 5th of 2024, when the facts of the case were revealed by the plaintiff's attorney himself. So clearly, this affidavit, which is not contested and can't be contested by the other side, is that the reasonable anticipation of litigation occurred on March the 5th, 2024. Everything after that is in the way of communications between and among the insurance company, the insured, and or defense counsel and or other agents is all privileged. I've tried to explain this repeatedly, but I think the fundamental misunderstanding of the law applicable to privilege here is the impediment to why this hasn't been able to be resolved. We have no material that is not privileged that might be described by this very broad term that he keeps using of incident reports or investigation reports. So we have established the date of reasonable anticipation of litigation. We have said that we have withheld material that was created after that date, that was communications by and between the insured, the insurer, the agents, and or defense counsel, and have properly asserted privilege to those things. So again, we have no non-privileged material to produce. So that's just one, and we have arguments about several of these other specifics as we get into reservation of rights letters and other complete irrelevancies in the matter. But I think the first point is that we have asserted privilege. We properly stated that we were withholding material described in our privilege log as communications between the insurer and its representatives. And we've stated the date of anticipation of litigation and that there are protected materials and there's nothing else out there that's non-privileged, so nothing to produce.
And Judge, if I may.
Okay, yes, you have the final say.
Yeah, so just a few points there. We're obviously not asking for communications between, defense counsel and their client. That's obviously covered by attorney-client privilege. We're not asking for those kinds of things. The suggestion that, that their client has absolutely nothing to do with this, well, our client contends that there were Texas trucking employees there on site that were directing the job, what was happening at the construction site. And in addition to that, there's also a indemnity agreement signed between Jimmy Evans and Texas Trucking, whereby Texas Trucking agrees to oversee operations there at the job site. So there's involvement there. As far as depositions, we're working on getting those scheduled right now. We're trying to get them done in January or February. The case is set for a separate trial on May 5th. So there's still discovery to be done. I mean, there's outstanding discovery requests right now to all 3 defendants. So there's still a lot that has to be uncovered in this case, and frankly, we haven't received any. The only thing that defense has produced in this case is an insurance policy. I mean, incident reports are discoverable. I mean, that's information that we routinely ask for in discovery, and it's not covered by the work product privilege. Obviously, under the rules, there's exceptions to the work product privilege. And one of those is when there's statements about what happened, photos, videos, that's in the actual letter of the statute. So we can't hide incident reports and disciplinary reports and training reports that were made subsequent to this incident under the cloak of this is work product privilege. And again, all the other defendants in this case, they didn't lodge those objections. They simply said, no, we don't have them. And it seems striking to me, that if you look at the photos of this incident, it's an entire large 18-wheeler trailer that fell on our client's tractor trailer. This isn't a minor incident. So we know that there's an incident report out there. None of the other defendants have it. It appears that Texas Trucking is the party that has it because they're claiming that they're withholding information. So really, we're just trying to figure out, who has what, and incident reports are just not covered. Incident reports, disciplinary action, those aren't things that are prepared in anticipation of litigation. They're just simply things that document what happened. There's no strategy there. There's no mental impressions of attorneys. It's just documenting what happened. So that's all we're asking for here and I'm happy to go through each of those one by one, Judge. But however you'd like to handle that.
Okay, yeah, if you're looking for rulings on discovery requests, I'm going to need more than a vague statement about what they are.
Sure. Sure. We're happy to go through them one by one.
And have y'all conferred about these?
Well, I tried, Judge, and the response was, we're standing on our objections, set it for hearing. I hear the court setting hearings in February. And I mean, we did correspond back and forth after that, but I mean, I'm sorry.
Yeah, I think you need to bring them up. Share your screen.
Sure.
Tell me what's in contention, and we can go through them one by one.
Sure.
But you only have 30 minutes total, so you need to get moving.
Yes, Judge. All right, Judge. Can you see my screen there?
I can.
Okay. So we'll scroll since we're pressed for time here. Here's the first one. All investigative reports related to the incident in question, including documents, memorandas, photographs, videotapes, movies, statements, reports, drawings, tangible things attached to them. Again, this is an investigative report. It's just, correspondence, emails that discuss the incident. We're not looking for anything prepared by, counsel. And again, we're looking for items that just discuss what happened. We're not looking to figure out what strategy is there. We're looking for things like witness statements of persons with knowledge of relevant facts and photos and videos. That's direct from the exceptions to the work product rule under 192.5C. That language is directly from from the rules.
Judge, if I may, if you'll scroll up, if you'll scroll up a few sentences there, he'll see that our response in the discovery was, we're asserting privilege, but as to the exceptions for photographs, videos, statements, and so forth, see the other responses where we provided that material. We know what the exceptions are, and we've provided all of them. What's left is the communications. Again, he seems to think this is limited only to communications between the defendant and counsel. That is completely wrong. If the insurer exchanges emails with the insured from the point where they know there's a reasonable anticipation of litigation, even though we haven't been hired yet, and that could be an exchange of emails about what was going on and what their opinions are as to what took place, that is fundamental work product privilege. Okay? So does it have to be core work product established by a defense counsel? No, but that's not what the rules apply. So we have provided the exceptions to work product. We provided all that material. He didn't point that out, of course, but his own response there shows that to be the case. So the only thing that is left is communications by and between the insured and their representatives, insurers, agents. That's what we've asserted privilege to. That's a proper assertion, And we've provided the affidavit from the adjuster to establish the date of anticipation litigation, which he has done nothing and can do nothing to dispute. So what's left is the communications that are in the claim file. That's all it is. We've identified them as such in the privilege log, and we've properly asserted the privileges that are applicable here. So there's nothing left that is non-privileged to produce.
And Judge, we haven't received anything in response to this request. I mean, we did not receive an investigative report. We didn't receive any of these things that we asked for. Nothing was produced. Just to be very clear, there was no documents were produced responsive to this request. In fact, no documents were produced in response to any of our requests. So that's simply not true that that these requests were responded to. I mean, we didn't get a single investigative report. We didn't get a single photo. We didn't get a single statement. Nothing. I mean, and we're not asking for communications between the insurer and you know and the client. What we're looking for, and even then, there's an exception to that rule. There's witness statements and statements of any persons with knowledge of the relevant facts. There's an exception to the work product rule for that. I mean, this is why we get all the time in discovery, we get emails, internal emails between employees of defendants discussing what happened, text messages, memos, documents. That's all information that's discoverable. And it's not prepared because there's litigation afoot. That's just information that companies keep to document what happened. That's the purpose of an incident report, is to document what happened. And that's discoverable. I mean, it's very clearly right there in the exception of the rules.
Judge, our response there, as I said, scrolling up a few lines, says for photographs, videos, discoverable witness statements, see the other responses to requests 1 through 4. So to the extent we had anything that is an exception to work product, we have produced that. But correspondence between the insurance company and the insured is not discoverable once the anticipation of litigation is in place. And that certainly that was very clearly established here because the plaintiff's attorney called and described this horrendous event on the date of March 5th of last year. So anything after that, and again, communications between the insurance company and the insured do not fall into the description of a discoverable witness statement. So he's completely wrong about that. But coming back to the bottom line here, we have nothing that's not privileged. So there's nothing to produce. To the extent there were things that are exceptions to work product privilege, we produced them. Why do we have nothing else to produce? Because we weren't there, we weren't doing anything. And I'll tell you a minute ago, he now says we were there and overseeing the site. That's the first time I've heard that. And he certainly hasn't pled it. In a year and 4 months since he filed the case, he's never pled that. But we weren't there. We don't have anything to do with this. And that's why we don't have anything except privileged material within the file that was created after the date of the reasonable anticipation of litigation. So this is a simple matter. These materials are privileged. We don't have any non-privileged material to produce about this. And his statement that correspondence between the insurance company and insured is a discoverable witness statement patently does not comply with the description of that in the rules.
Okay, and let me just ask, Mr. Schreiber, because I think your opposing counsel indicated nothing has been produced. If that is true, does that indicate to the court that you have no photographs, you have no witness statements, video, etc.?
We obtained some photographs after the fact, and so we're quite aware that there are exceptions to the work product privilege. So if there were photographs, videos, witness statements, if we had them, we produced them. If we didn't, then we didn't have them. We have nothing. Because again, we found out about this I believe it was about 9 months after the accident. And because we weren't there and we weren't involved, and again, the responsible parties, the driver of the other truck, the owner of the truck, the employer of that driver, the owner of the equipment, the premises owner, are all defendants in the case, and they are none of us. So why would we not have anything really about this case, or have very little about this case? Because we weren't there, we weren't involved. But as far as privilege goes, if we had material that fell into the exceptions, then we produced it. If we didn't have those, we didn't have them to produce. We didn't. So that then leaves only what's left in the privileged claim file that we have not produced and believe that we are on solid ground legally in protecting that privileged material.
Yeah, again, Judge, nothing has been produced. I mean, if you look at the Bates labeling from defendant, I don't even know what number there would be. There would be the insurance policy that they reluctantly produced. Um, if the answer is we don't have anything, then we don't have anything. That's fine. If the answer is none, it's none. But clearly they're withholding information that is clearly marked laid out by the rules that it's discoverable. And I mean, they're claiming that we weren't there. That's not my client's contention. My client contends that he saw Texas trucking people, people wearing Texas trucking gear, so to speak. He saw Texas trucking vehicles at the site. So I mean, the contention that they simply weren't there, that's up for debate, right? I mean, we don't we that's in dispute, right? Um, and it's I it's interesting to me. In this case, everybody says that they don't have anything, and what they and all the other defendants did was because I picked up the phone and talked to counsel for every single other defendant in this case, and we went through their objections, and they simply removed them and said none. So it's odd that every other defendant just agreed to remove their objections and said none in response to the requests that we made. And the only defendant that's standing on their objections and clearly withholding information is, fighting us on this. Again, there's a contractual agreement between them and the job site owner whereby Texas Trucking is supposed to run the show. They're supposed to oversee the entire operation there. So to claim that their client Texas Trucking wasn't there and wasn't doing anything at the job site is impossible. I mean, there's a contract that literally says that they're supposed to run the job site. So
That is
it's
not what that indemnity contract says. It's a standard indemnity provision. And frankly, the reason why nobody's following up on it is because of the anti-indemnification statute. So learn some law about that issue, number one. And two, I find it interesting that as your story
I'm going
keeps
to stop
growing,
you right there because you need to be addressing the court and not opposing counsel. Um,
we keep having the inference here that we're hiding something because we haven't produced anything. The fact is we weren't involved, and so we don't have anything to produce other than what's in the privileged claim file.
okay, this request number 5 is denied. The motion to compel is denied as to that request. Move to the next one. And
There
y'all
are
only
actually
have about
there
7
are
minutes.
there are 5 requests that all basically the same thing where we've asserted privilege. It's just different versions of incident reports, etc. But there are 5 that are the same thing.
All right.
I'll give
Mr.
you the numbers.
Silvero, is that the case that they're all really, you're seeking? If we're all here on the claim file, then I think you have your answer on that.
Just so you know, it's RFP 5, 17.
so Judge, we're not asking for the claim.
22,
We're asking for
25,
specific.
and 41.
Yeah, so Judge, we're asking specifically for, we're not asking for the entire claim file. That's privilege. We don't want the claim file. We're asking for investigative reports, incident reports. That's request number 5. Number 6, a copy of each and every umbrella policy and insurance.
I'm sorry. We're trying to wrap this up in 7 minutes. There are 5 requests for claim file materials. 5, 17, 22, 25, and 41. And I think the court's already ruled on number 5. If I'm hearing the court correctly, it would be the same. They would deny the motion to compel on the other 4.
Judge, if we could just kind of go through these in chronological order, I think we can get through them pretty quickly. Is that okay with the court?
Um, I am going to cut you off at 30 minutes so you can do your best.
Understood. So number 6, we're just asking for any and all insurance policies under the rules. They have to produce that. There's no valid objection there.
And they've already done it, is what your motion said. You did get the insurance policy.
right?
Yes, we have the primary insurance policy, but if there's any other coverage there, that's also discoverable.
Well, it depends on what you pled in your pleadings. You don't just automatically get an excess policy.
Sure. So we pled that the case is worth we're asking for damages in excess of 1 million and below 5 million. So the primary policy they produced is 1 million.
Judge,
All
we
right.
have from the parties who there's at least an arguable case of liability, the owner of the other truck and the driver of the other truck, they've identified 3.5 million in coverage. This guy had 20,000 in past medical until he, fluffed up the expenses with some objections recently. But that's $3.5 million of coverage. We've identified 1 million in our underlying policy. And whether or not there's any policies beyond that, there would never be any hope of them being reached. So you're right. I agree. We've provided them 1 million. That means they're aware of $4.5 million in coverage right now in this minimal case.
Okay. If the pleadings ask for in excess of the primary, then you have to give the excess policy.
I'm sorry, if the pleadings say what?
If the pleadings are for $5 million and you've only given a $1 million policy, I think that makes any excess policy discoverable. I don't have the pleadings, that nobody has mentioned that one way or the other, so I don't know what has been pled.
I'm just pulling that up here.
Judge, and again, we're pressed for time. If we could just kind of move through these, if that's okay with you. Number 7, we're asking for other incident reports that took place in the last 10 years. We're asking for that because it could show a pattern of conduct of other negligence or recklessness and nothing being done about it. So we're asking for that to be granted.
Okay,
Judge,
that one's denied. That's overbroad on its face. It's not reasonably tailored. The time period's overbroad, not substantially similar to what happened here. No, move on.
Judge, the pleading does say relief over 1 million, and we have
Okay,
4.5 million already identified. So we would argue if there was an excess policy, it wouldn't be relevant.
it's not discoverable based on the pleadings at this time, so.
Okay.
14, criminal records pertaining to plaintiff or any other witnesses. The responses will supplement and hasn't been supplemented.
Well, Judge, that plaintiff just supplemented some discovery and said we'll supplement. So that's an entirely appropriate answer. When and if we have something like that, we will supplement.
Yeah, I don't see anything for me to rule on there. I mean,
We can move on, Judge. That's just
okay.
request for time. Number 17, any incident reports that pertain to the actual job site here. I think that's clearly relevant. It's the actual job site where this happened. So any other accidents or injury events there in their possession.
Judge, this isn't even limited to us. It could be other parties. What time frame is not even in there specifically. And so again, incident reports. This is another that falls into the privilege section. This is another one of the 5 requests where we've asserted privilege, and you've already denied the motion compel on number 5. We would suggest this is the same thing.
And Judge, we did limit it to their possession, and then this job site is actually complete now. It's like an apartment complex or a condo complex, so there wasn't work being done there for 10 years. This is pretty limited. Anything in their possession that happened at this specific location.
Ever, it appears, right? And involving who or what.
Texas Trucking, any documents in their possession, Judge.
Okay, it's denied.
Okay, the next one is 18. 18 and 19 are both asking for employee manuals and safety manuals. If they didn't follow their own rules and procedures, then that's evidence of negligence.
Rules about what? The only thing that he's pled is we dispatched. And of course, there is no negligent dispatch cause of action. So he wants just any employee or safety manual regarding anything that the company does. And the only thing that he's pled is that we dispatched these trucks.
And again, Your Honor, our contention and discovery is ongoing. We'll amend our pleadings as we get more information. But our understanding is that Texas Trucking was there kind of running the show. So their policies and procedures are irrelevant.
Funny, funny that counsel has not pled that, Your Honor. That's outside of the pleadings. It's an argument that's been developed for this motion to compel today. These requests about employee manuals about any subject, there's not even a time frame listed for them. I mean, if he wanted policies and procedures related to dispatch, which is something that he's pled, then fine.
Again, Judge, discovery is not that limited. It's broad. I mean, we're just asking for employee and safety manuals. It's
That's exactly the problem. It's the overbreadth of these.
Okay, I am going to deny the motion to compel us to these two.
all right. The next one is any documents relating to an agency regulatory agency investigations or citations or warnings from January 2014 through the present. Again, that's evidence of any kind of negligence, not following the rules essentially within the last 10 years. We think that that's relevant, again, to show if there's a pattern of conduct there, of negligent conduct.
Judge, this is the very definition of a harassing, sanctionable discovery request here. Every regulatory issue, investigation, citation, warning regarding who, about what, for 10 years? I mean, the incredible overbroad scope of this and the total irrelevance of all of this, and not even limiting it in any way to the negligent dispatch that he has pled, this is just an absurd request and an example of why we've had a breakdown in communications here. I mean, we weren't in a position to remove objections that were issued in good faith and in compliance with the rules, and this is one. Vague, overly broad, irrelevant, and especially not in having any limits as to who and what about, and for 10 years for a party not involved in this event.
Okay, so the motion to compel is denied. And if this is your form discovery counsel, I think you need to consider spending some time rewriting it. Anyway, y'all have reached 30 minutes. Is there anything that remains?
There's still a few. There's one, two, three, 4, 5, 6.
Okay, well,
There's
a bit of a
about
rhetorical question. Is there anything different? Is there anything that you really think you're entitled to that you don't have and you're asking the court to compel? Because based on the discussions we have had, I now see why defendant has stood on their objections and required the hearing.
Judge, there is one area we want to make sure we do get a ruling about today, and that's 2 requests for production related to reservation of rights letters. And I've attached the In re Madrid case that we uploaded to the box and provided copies of for everybody, which makes it quite clear that that is non-discoverable.
Yeah, Judge, and we think that that goes to, for example, if that goes to the collectability of any judgment that's out there. If there's no coverage here, then we're entitled to know that information because it affects our ability to collect on a judgment.
On Judge, in that In re Madrid case there, we cite what the Supreme Court's position is, which is, quote, determining the settlement value of the case is not related to the merits of Calvillo, that's plaintiff's negligence claims, or to Madrid's defenses in the case. And there's no showing the information appears reasonably calculated to lead to the discovery of admissible evidence. So it's privileged and it's irrelevant. And the Supreme Court has made that quite clear. It's outside of the scope and existence of an insurance policy.
Okay. I never understood why people don't disclose these, I think, but that's more of a personal opinion than anything. Insurance isn't going to lead to the discovery of admissible evidence. Mr. Silvero, do you have a response to the case that counsel has cited on those reservation rights? Because I haven't seen anything new on that in a
I do
while.
not, Judge. I do not.
Okay, then I don't think you are going to get them.
Okay, there's just a few here that I'd like to cover with you briefly. I believe you said you denied it as to incident reports, training reports, so I guess we can skip that. We asked here in interrogatory 4 for them to identify any personal injury lawsuits filed against them in the last 10 years. Again, we're trying to see if we tailored it in terms of temporal scope, and we limited it to personal injury lawsuits. We don't want to know about business disputes, breach of contract, anything like that. And again, if there's a history of negligent or a pattern of negligent conduct there, we think that we're entitled to that information as well. And the jury's entitled to see it.
Boy, Judge, any personal injury lawsuits filed against Truckee for 10 years for anything, for what, not even remotely limited to what might be the facts of this case about dispatch and so forth. So again, another extremely overly broad and irrelevant request.
Okay. So I think 10 years on its face is overbroad, and I think there's a very old Texas Supreme Court case on that point exactly.
And Judge, we're happy to limit it to 5 years, say.
Well, I am not here to rewrite your discovery request. I'm here to rule on the motion, and so it's
Understood.
denied.
Understood. Um, 7 is essentially identical. And then on 10, we're asking, have all the insurance policies been disclosed? And we did not get a response to that. Again, this one goes to excess coverage.
I
Again,
think judges, you already ruled on this issue of the policies.
Yeah, I think under the current pleadings, you have the policy that you're entitled to at this point in time, so I'm
right,
not sure.
Judge. That's basically all I have. So nothing further from our side.
Okay. All right. If somebody wants to put together an order, I will be happy to sign one, or you have the rulings on the record, but I think you have what you need.
Thank you, Your
Thank
Honor.
you.
All right. Y'all are excused from the virtual courtroom.
Thank you.
Thank you.